All right, good. Happy Thursday, everyone. Once again, we are reconvening our Doc Talk. I know that we are in the last week of summer and getting ready for for the next quarter, the end of the year quarter. And we wanted to kind of revisit some of the important news we discussed in our WCH Insight. And one of our speakers and interviewers was Jennifer Brown, who is a general counsel and an expert in No Surprise Act. And in our WCH Insight, we touched on the topic and we gave a very thorough description of the law, how it impacts providers, how it impacts the patients. But I think we need to revisit and kind of give a nice recap and a very short recap of what the law is all about, what kind of influence it has, and how does it really protect the provider, or it does not, or what influence it has on the patient. So, Jennifer, thank you once again for stepping in and covering this topic one more time. I know we have a lot of specialties in the emergency medicine department, urgent care walk-ins that are definitely going to listen in and probably ask questions. So, the topic is very important. The law is fairly new. I think 2022, right? It went live.
Correct.
So I think we need to kind of just go over some of the important aspects. And I guess I'd like to start off by asking you, why is no surprise important for healthcare providers?
Thank you, Olga, for having me. Yes, the No Surprises Act is critical for many providers. The No Surprises Act was effective about 3 years ago, January 1st, 2022. It prohibits surprise billing in certain circumstances, and that probably affects many of us on the phone call today. For example, it applies to emergency medicine providers, as we all know. It provides that emergency medicine providers cannot balance bill the patients, and I would like to say that that is a very critical point to the No Surprises Act. It does protect patients, and it prohibits providers in certain circumstances from balance billing the patient. It also applies to non-emergency services when those services are provided at an in-network facility.
Mhm.
And I'm not sure if there are any air ambulance providers on, but it also prohibits balance billing for air ambulance services furnished by those out-of-network providers.
Okay, and it covers pretty much those specialties in any state, right? Doesn't matter if the patient is Medicaid HMO, Medicare Advantage plan, or commercial plan, right? It applies to every single patient.
This it generally applies to many patients. I don't want to say it applies to every single patient. I don't want to overgeneralize, but yes, this applies. And for example, the PPO plans, for example, yes, this absolutely prohibits balance billing in those circumstances. This is a federal law, which means it touches 50 states. Even if each state did, if a state had their own state law prohibiting balance billing, this will serve to supplement it and prohibit balance billing for additional plans. I know a lot of states, I believe it's 21 states, New York, where we are, included as a bifurcated state, which means that there was a prohibition on balance billing. I think that has been in effect for about 10 years, but that only covers certain plans. The federal law is going to come in and grab the rest of those plans that may not have been captured by those state laws already prohibiting balance billing. And what the federal law has also done is prohibit balance billing, which protects the patients, which is great. But it also provides the providers with a mechanism by which they can, we'll say, challenge the payment they may have made, they may have received from the insurance company. And the federal law provides for a very detailed and somewhat lengthy independent dispute resolution process. Olga, please let me know if you want, we can go through.
Oh, no, not on this call.
But if anyone does want to go through those steps, you know who to call.
Yes. So I guess that will lead on to the next question. If there's providers or healthcare settings that are currently in network and making this decision because whatever reason is they're not happy with the contracted rates, they can't negotiate their rates, they want to opt out. They need to carefully understand the challenges they're going to face and the restructure they have to make inside their office, right? Can you talk a little bit about that process?
Absolutely. And I know many providers, for example, my my employer, we had an in-network strategy. We worked very hard over many years to procure a fair and reasonable contract with the payers. Now, what has happened, unfortunately, as Olga, I'm sure
Yeah.
your clients have seen, since January 1st, 2022, payers have been revisiting contracts, and that has placed providers, us included, in a very challenging position because I'm sure as each one of us here has procured and secured a contract, it took it just took a lot of manpower, a lot of hours, a lot of time, and you were ultimately, both parties were satisfied with the outcome of the contract. And since the No Surprises Act has come into play, a lot of payers are revisiting what they believe is a fair payment, resulting in amendments or cancellations of contracts, which is requiring providers to become very familiar very quickly with the independent dispute resolution process.
Mm-hmm.
What do I recommend for providers who are facing this as a reality? Understand the law and become very aware and become almost an expert in the process, because the process will result in fair outcomes. And CMS has issued what's called public use files. Feel free to navigate the CMS website to take a look. Providers, once they wrap their arms around this process, are pretty successful. I want to say, don't quote me on the numbers, but it's probably about 85% of the time providers are successful. So if you can wrap your arm, it's not a great situation. What's going to happen is your cash flow will be challenged because if you're at a network, the payers are going to drop your reimbursement, which means you have to fight for what you think is fair, and you have to go through the process. So it does take some time to get through the process, but if you do it successfully, you will see probably a pretty good success rate once you have wrapped your arms around it. But it requires a lot of administrative time, and it does require additional
Training staff. Yeah.
additional training, but also keep in mind there are fees associated with utilizing the IDR process.
Yeah.
You do have two separate types of fees, which again, it's all a financial consideration in addition to an administrative, right? You have to have someone policing this process very carefully. You have a non-refundable administrative fee. So every time you enter the process, as of 2024, it's $115. Every time you utilize the process, it's $115 that you won't get back.
Per date of service, right?
Per dispute. So if you're able to batch,
Okay.
there are some efficiencies.
Right.
IDR does permit some efficiencies such as batching. If a handful of claims match the criteria, which is very specifically outlined, you can put multiple claims into one dispute, and each dispute will get a non-refundable administrative fee. And you also have to include, you also have to pay ahead of time the IDRE fee. So that certified IDR entity that will be evaluating the case, you have to pay that fee up front. You will get that back if you win, but you do have to put all of those fees, you have to pay all of those fees up front.
Of course. I know that typically, like in a medical setting, right, there's a billing department, right?
Correct.
And the billing department typically has coders, collectors, and billers. Do you feel, from your experience of working with NSA, do you feel that a person that will be responsible for this type of claims, do they need to go through specific training, right? Do they need to get exposed to understanding the law, or only a legal level authority, like an attorney like yourself or somebody in the lawyer's office, can only utilize these type of claims? Is it possible for a regular biller to be able to manage negotiation and filing of these claims?
I do think so, yes. I think with sufficient training, and you may need a lawyer or someone who has really spent some time in the law and has become an expert, that person can train billers or really whomever you feel is appropriately tasked with managing this process. I don't think you need to go and hire 10 lawyers to do this. This is absolutely something that can be brought in-house, that can be done by a biller. It is a very, tracking the claims and monitoring the deadlines. It's an unfortunate but manual process. Some items can be streamlined. You can include some sort of technology. I think it's you could do like a bot, which is, I think, robotic processing, something along those lines. But keep in mind, most of this will end up being manual.
Gotcha. Okay. So any providers today that are considering, going in out of network, right? Please keep in mind, as just a an important note that it is 90 days to opt out, right? There is a
Yep.
time filing for that to take place
Hmm.
until the insurance company really sends out a letter that says you're out of network.
Hmm.
I know from my experience of doing credentialing, doctors like, I submitted the letter, I'm out. No, you're not. You're still in network. We can see in the directory. Patients consider you to be in network. That's why they came in for the visit. So it's very important to cover all details, right? To make sure that everything is set up
Hmm.
properly
Correct.
before you start utilizing out of network billing. So I think that's a really, really important point for the providers in specific specialties, especially emergency medicine. Jen, anything else that we want to leave off today for our clients or our listeners? Any way maybe they can go to read upon about the law, or is there any kind of help available or something that you can recommend quickly?
Yeah, absolutely. I would certainly navigate the CMS website where you can find the IDRE guidance for disputing parties. That's probably a pretty quick Google. That's definitely the place to start if you are considering out of network as the strategy for one reason or another. There are many legitimate reasons these days that an out of network strategy may prevail at your practice, but I would certainly use all of the resources that CMS does have to offer. And frankly, there are a ton, and it's pretty clearly written. But also feel free to reach out to any of your experts, any of your trade associations. If you're an emergency medicine provider, there's EDPMA has excellent resources. I'm very involved with the Emergency Department Practice Management Association. Um, Utilize the associations. They're very involved, they're very active, and they have a lot of experts on
Perfect.
hand that can also talk you through it. And although, as you mentioned, the termination period, use that time to really get familiar.
Good
You're,
point.
you're gonna need you're gonna need that time, and just be aware that reimbursement is going to be a little bit slower.
Yeah, absolutely. I think it's great stuff that we're able to share. And if anyone has any additional questions, please write to us after the podcast. I'll send it to Jennifer. She'll be happy to respond. But information is there, resources are there. Please use them and let this law, help not only the patients but also prevail any kind of challenges for the providers as well. Jennifer, thank you so much for your time and your knowledge. We really
Thank
appreciate
you.
it. Have
Thank
a
you for having
wonderful
me.
summer.
Have a great
Thank you.
day.
Take care. Bye bye.